Good evening, everybody. Welcome to tonight's webinar on consent and capacity. For those of you who attended our former webinars, you'll probably be well acquainted with the format and me. But for those who haven't, I am Cara Moroney. I'm the Director of Professional Conduct, and I'm going to be running through parts of the presentation and running over the principles of consent and the requirements of the Healthcare Consent Act. Also, I'll refer to that in the presentation sometimes as the HCCA. We also have with us tonight remotely in Sudbury is Heather Westaway. She is a registered kin, registered with the college, and she's here to assist us with answering questions and providing in-practice examples from her own experience. As well, she'll be talking about the capacity portion of tonight's presentation. Heather has extensive clinical experience in geriatrics, chronic disease management, and hospice palliative care. She has developed and implemented hospice palliative care end-of-life care policy and provided education around healthcare consent and advanced care planning. She also holds a faculty lecturer status in the Clinical Sciences Division at the Northern Ontario School of Medicine. So she is, has lots of wealth of experience and expertise to share with us tonight. And then we also have Ryan Pastana, our communications analyst, who will be moderating today's session. As always, you can type in your questions at any time. I cannot guarantee that we will get to all of them. Sometimes time doesn't permit it, or sometimes the question requires a little bit more thought than we can kind of do on the fly. We will answer all questions either to you individually or in an FAQ document that we'll put up on the website likely within the next month after this webinar. So we will get to your questions in some manner of speaking. And so just as we begin, we've chosen consent as our third webinar because along with record keeping and professional boundaries, it's a crucial aspect of any practitioner's practice, and it's one where we do find that there are some gaps between the theory of what it is and what people are actually doing in practice. And also to let you know that with the QA program and the peer and practice assessment that we'll be rolling out over the next year, there will be a focus on consent, and it's vital that practitioners know this area, and the best way to know this area is by implementing good practices in your practice when it comes to obtaining valid and informed consent. Also with respect to the QA program, being registered and attending tonight's webinar, you can count that towards your CPD on your self-assessment. And for those of you who are tuning in, we want to thank everyone for taking the time out of busy schedules and out of their evening. And I think it really does demonstrate that you care about your practice and that you are educating yourselves and engaging in that reflective practice that's part of that QA program. Okay, so on to the first slide, which is the Healthcare Consent Act. I know how everybody loves legislation. I do, because I'm a lawyer, so I'll try to break it down a little bit. But I did take a lot of the language right from the Act, and it is a fairly detailed Act, and for the most part, it's pretty good. So there's three areas that the Healthcare Consent Act deals with where consent is required. Consent to treatment, consent to admission to a care facility, which is defined in the Act, and consent to personal assistance services, which are also defined in the Act. We will be focusing on consent to treatment, as this is probably the most common for registered kins, and it's also just what people do every day, typically in their practice, unless you're non-clinical. So also along with today's webinar, and the slides were posted on the website, we did provide you yesterday with a short quiz just for you to take to just gauge your own knowledge of this area prior to the webinar, and hopefully at the end of this, where there may have been gaps, you might feel that you could answer it a little bit better. So there was a first question on here that said that the Healthcare Consent Act is the only piece of legislation dealing with consent in the healthcare context, and that is false. There are other pieces of legislation, the main one being the Personal Health Information Protection Act, which has a lot of provisions in it around the consent to collect, use, and disclose personal health information. There are also standards in which colleges have that will require consent for different things, like consent for fees and billing, or getting consent to use a supervised, or using support personnel, sorry. So it may not be enshrined in law, but there's still standards. But we won't be focusing on that. We will be focusing on the Healthcare Consent Act and on consent to treatment. And then questions 2 and 3. Question 2, the Act mandates that consent be obtained for treatment. That is true. And you'll see on the slide that we have the definition of treatment. And the question number 3 was that taking a health history is part of treatment, and that is false. You can get consent for it, but you don't absolutely need it. Okay, so the next slide. So we have this lovely stop sign, and we just wanted to bring this up because this is the starting point. Before you start treating anybody, you have to obtain consent, valid, informed consent from the patient client directly or from their substitute decision maker if they're not capable. And we'll get some more of this later. And it's not only your legal obligation under this act, but I'd like to include that it is your ethical obligation. We don't want you to just do this because you have to. It's a philosophy and something that all practitioners should really value, that client-centered care approach. So on that, going to the next slide, there is one exception to providing treatment with consent, and that's in an emergency situation. An emergency is defined in the Act, and it's defined there. It's in the italicized version. Now, there are instances, and the question on the quiz was number 4, if there is an emergency situation in which someone requires treatment, you do not have to attempt to obtain consent. And that's false. The key word in there is attempt. You know, if you feel that you have a chance to try to get consent without causing further harm, you should attempt to do so. So, you know, someone may not be fully unconscious. You may be able to ask the person if they consent to whatever it is that you need to do depending on the situation. So it will depend. So that is false. You need to at least think about whether or not you can attempt to get consent before moving ahead. Okay, so we've talked about basically, I've touched on the basics. So you have the Healthcare Consent Act. You have to get consent for treatment always, except the one big exception being an emergency. But let's kind of step back before we proceed and kind of emphasize again, well, why is consent important? You know, why was this act created? Why can't you just go ahead and treat someone? And it may seem obvious, but the fact is that we see too many instances in practice from not just kinesiologists, but across many professions, that consent is treated like a routine step. And it's just something that needs to be checked off or a form that needs to be signed. And I can't emphasize enough that it's not just a routine step and it's not just a form that needs to be signed. It is critical to a patient client's right to autonomy and dignity and choice about their own healthcare needs. And generally in our society, we're actually always moving towards increasing that right. If you see the new plan that the minister just unveiled, I think it was last week for Ontario, it's all about patients first, patient safety. There was the recent Supreme Court of Canada case that has now, within many parameters, allowed doctor-assisted suicide. That is, the philosophy behind that is people have the right to choose what they want to do with their own health. Now, whether you agree with that or not, that's not the discussion, but the point is that we're always moving towards increasing client-centered care. And so when we get to question 5, which is one of the purposes of obtaining consent outlined in the Healthcare Consent Act is to ensure practitioners are protected from liability. And that is false. While it is true that if you obtain valid and informed consent, and someone sues you, that's a pretty good defense. It's not the purpose of the act. Consent is about the patient-client. It's not about you. So I just wanted to bring that up, but certainly it does help. Okay, we might just stop and just double check for any questions. Okay, we don't have any questions at this point, so we're going to move on to the next slide. And we've got the elements of consent. This was a question, there are 4 elements of consent, so this is true. We asked in the quiz if you could name them, so this is a good chance for you to gauge how much you know. There are 4 elements up there. They're pretty straightforward. Number 1 seems obvious, but it kind of gets at that idea that you can't get a consent form, like a blanket consent form that just says, I consent to the treatment that I'll be provided. It has to kind of outline what it is. Consent must be informed. We'll get to that. It must be voluntary, and it must not be obtained through misrepresentation or fraud. So hopefully that's all self-explanatory. And then we're going to get into the discussion of informed consent. So informed consent is just one element of consent, but people will often refer to informed consent, as an all-encompassing, but it's actually only one component of consent. It's just that within that component, there's several subcomponents, if you will. And we also had a question on here that informed consent is one component of consent. That's true. And then question 8 is, informed consent means you have discussed with the decision maker the risk of a proposed treatment. It's a bit of a tricky question because it's actually false, because it's not just that. It's also talking about the nature of the treatment, the benefits, the side effects, the alternative courses of action, and the likely consequences of not having the treatment. A lot of practitioners think it's just about talking about risks. And generally the difference between risks and side effects is that risks are more about potentially what might happen, whereas side effects are something that would almost for sure happen. So, a treatment that, a medication that has the side effect of being drowsy. It's almost a 99% chance that you might feel some degree of drowsiness. But the risk of taking a certain medication is that you may have a heart attack. So that's kind of a little bit of a difference there. So that's we'll move on, and then we see under that one bullet, number 3, and again, these 6 elements are taken straight from the Act. Number 3 talks about material risks. And when it comes to material risk, you must be frank with the patient, and it's based on what the patient needs to know, not what you think they need to know. So it's, again, patient-centered. And it's really important when it comes to risk, because that is usually what makes the decision for somebody, the risk and benefits. It's basically allowing the client to make a pro-con list, if you will. And pro-con lists, we use those every day. We use them when we're deciding whether or not to accept a job offer or buy a house. So, if you want to think of it that way, you're giving them the tools to make their pro-con list in order to make that informed decision about whether they want to move forward. There's also an implied duty on members to be current with the state of science on a proposed treatment, because, especially cutting-edge technologies or modalities, the risks and benefits might be changing as they get more data on it. And also with material risks especially, not what is material, not all risks are material. It kind of depends on the client, it depends on the nature of the risk. There's also a term called remoteness. So you may have, just the mere possibility of a risk doesn't mean it's material. But if the risk is very serious, even if it's very remote, you may still want to disclose it. So the most obvious is death. So there may be a very low risk of death, but the risk itself is very, very serious. So you probably want to mention it. Another serious risk would be heart attack. And just when people use lists to give to patients or clients that list all the risks and benefits, we want to use caution with this because they may not be exhaustive, they may become outdated, and they may not be fully relevant to a patient client. So what a material risk is to one client may not be to another. So for example, a course of treatment that could result in pain or injury to a person's joint functioning may be more relevant to a high-functioning athlete than to a person who maybe doesn't engage in much exercise. So, you have to change the way you approach it, and you have to think about your client. From the client's perspective. And so this part of consent is really all about dialogue with the patient-client, making sure that they have all the information that's relevant to them, giving them a chance to ask questions, giving them a chance to think about it if necessary, or seek a second opinion. It's not done through a form. You really have to be talking about them and engaging them in that discussion. So I'm going to turn it over to Heather at this point because she's going to give some more clinical examples of different types of treatments and different types of material risks that come with them to give you a sense of what you need to consider. So Heather?
Thanks, Cara. Can you hear me, Cara?
I can. I think.
Okay, I just want to test out my mic. I'm assuming if you can that everybody can. So I just want to talk for a minute about the different types of treatment or situations of treatment that somebody can consent to. So you can consent to a one-time treatment. You can also consent to a course of treatment. So I don't know if you want to go to the next slide. We can kind of do this one together. So a course of treatment is most likely what kinesiologists are doing in their practice, right? We see somebody for a period of time for a particular health problem, and that's sort of going to help you determine the material risk. So what is the material risk of treating this person for this particular health problem over time? So when you're looking at what's involved in your course of treatment, that's how you're going to look at those things that Cara was talking about, your material risk and your material side effects of your treatment. And you can obtain a valid and informed consent for a course of treatment. So one of the examples that I can give you is if somebody comes to help, they want increased mobilization in their shoulder. So you're going to do some shoulder mobilization. When you are sitting down in that first visit, you're going to present to them the course of treatment or the series or sequence of similar treatments that you're going to do with them for their shoulder over a period of time. And you can take a consent for that course of treatment and explain the benefits and the risks for the treatment period so that you don't have to sit down and get an express consent for every component every time you see that patient over a period of time. Just keeping in mind that there are certain things that you're always going to take consent for whenever you're touching somebody in a sensitive area. If you're doing something new that you haven't done before or that you haven't explained before.
Okay, thanks, Heather. I think that hopefully helps to explain, hopefully helps to clarify for people that we want consent to be meaningful, but we also understand that there's a lot of pressure to provide treatment. If someone's coming in for a half-hour session, they don't necessarily want 10 minutes spent explaining every little thing that's being done. So like Heather said, when you have the different tools that you use that you discussed at the beginning, as you're using those tools, you may just want to quickly verify this is what I'm going to do next, and it may just be as quickly as, yes, that's fine. So it can be fluid and efficient, but it can still be very meaningful, especially if you've had that discussion with them up front. Other things that you would have to obtain consent for, and this is not in the Healthcare Consent Act, but just to touch on it here, is if you are performing a delegated act. So the person who's doing the delegating should also have that discussion with the client and saying, I'm going to be delegating this to the kinesiologist, and then you should verify that that consent was obtained. You should also obtain consent if you're going to assign care, which is different from delegation, because delegation is only for controlled acts. If you're going to assign care to a personal support worker, so that's another area. So it's not necessarily in the definition of treatment, but those are other areas to keep in mind where you should be obtaining express consent. Just like Heather said, also with sensitive areas, it may be a part of the course of treatment that you already obtained consent for, but it's very, very prudent that you do that. That's often an area where we see complaints, is that someone will come and say they didn't have consent to touch me there. I don't know, Heather, I'll just for a second hand over to you if you have if you wanted to provide another example just to help elucify this area a little bit more.
Sure. So the other thing that somebody can provide consent to is a plan of treatment. So this is a little bit more complex, and it usually involves a number of healthcare providers. So a course of treatment is usually the same healthcare practitioner doing the same thing repeatedly over a period of treatment time. A care plan or a plan of treatment may involve a lot of different components. So let's say somebody is hospitalized post-MI or after a heart attack. There may be a number of things involved in that plan of treatment. For example, drugs, ECGs, and as a component, a kinesiologist is going to come and walk with you every day and give you an exercise program. So this is something else that a patient or a client can consent to if the healthcare provider is providing all of the benefits and the risks and the alternatives, the consequences of all of the different components of a plan. In a situation like this, where the risk is higher than it might be when you're just working with somebody's shoulder, you're going to want to make sure that you go back and ensure that you do have an expressed consent for your component. And here's a situation where you might want to spend an extra few minutes and focus on the possible risks, the material benefits, and the material risks of the exercise treatment. And just verify, even if consent's been taken on behalf of the team, on behalf of the care plan, that you do have a valid and informed consent to do the treatment piece that you're going to be responsible for.
Okay, perfect. Thanks, Heather. Also on this slide, we do have a relevant to question 9, which is there are 2 types of consent, and the answer for that was true. We asked what they are. Again, we can't know what you answered, but a lot of people might have thought there were 2, and they might have thought they were verbal and written, but that's not correct. There's 2 types. It's express and implied. Within express consent, you can have written or oral or both, which is sometimes the best. And implied consent is implied through words and actions, and the standard is what a reasonable person in the circumstances would believe. So when you are relying on implied consent, you need to document those circumstances. It's obviously always best to have express consent, but I think when Heather was talking about that course of treatment and when you're doing a similar sequence of different activities, that's where maybe you can rely a little bit more on implied consent. But you do have to be careful with implied consent because, you know, there's different people act in different ways. So some people nod, like they might be nodding their head, but that's not saying yes. It just might mean that they're acknowledging that they're listening to you, but it doesn't actually mean yes. So you do have to be careful, and obviously you wouldn't want to rely on implied consent for anything, for any kind of treatment or action that had any kind of serious risk associated with it, or something like touching someone in a sensitive area. You really want to hear that yes, and that's express consent. When someone says yes, I consent to this treatment, I understand the risks and benefits, or, you know, depending on the nature. So I don't know if I'll hand it over to you, Heather, if you want to have a little bit more of a word on implied consent, an example of a good example of where implied consent might be valid and what to look for, or perhaps a not good example.
Yeah, thanks. So we'll come back to our shoulder. Somebody's in for shoulder mobilization. You've provided you know, the risks and the benefits and the different components of what that treatment might include at the beginning. So you've got a valid and informed express consent at the beginning. Now you want to use, let's say, a modality such as ultrasound on the shoulder. So you don't need to go back again and talk about the material risks and the possible consequences. There's an implication or an implied consent when you say to a patient or a client, now I'm going to use this modality, this ultrasound. This is what it's going to do for you. And, you know, if you roll your, you know, let's roll up your sleeve or take your shirt off and put a gown on, and we'll do the ultrasound. If the person is cooperating, they're nodding, like you said, to acknowledge that they're listening, they're doing what you ask them to do in terms of preparing for the modality, you might just quickly clarify, do you have any questions before we start? There's implied consent there. You have an express consent for the course of treatment and all of the different components. So you don't need to stop and have, you know, a long and involved conversation. You just sort of want to reaffirm that they understand what's happening, and you can use the implied consent in that scenario. We can never, just quickly touch one more time on sort of when we're talking about touching people in sensitive areas, that is a time when you would never want to use implied consent. So if you are working on a shoulder on a female and you have to sort of go down into the bra area to access muscles, ligaments, that sort of thing, you're always going to want to get an express consent for that, regardless of the fact that it's a component of shoulder treatment. Anytime that you are, you know, that you have sort of excessive touching of somebody, which obviously as kinesiologists we quite often find ourselves in that situation, you would want to stop and ensure that you have that express consent. And it would probably be part of the consent, the valid and informed consent at the beginning of the course of treatment. I just wanted to let you know that, you know, while we're treating a shoulder, there are times when I might be needing to treat the chest muscles, and I will always let you know before I do that, and you know, and ask your permission each time.
Okay, great, Heather. I think that's really helpful. Certainly helpful for me as a client to know what to expect. So hopefully it's good for the practitioners. And that is very important about the sensitive areas touching. And you know, sometimes you feel like you have a great relationship with a client, and they seem to understand everything you say, and you know, you get along really well, and you're just chatting, and so you move along with it. But you cannot assume that just because you have a good rapport with a client that they may not be sensitive to that, and they may not get very upset quite suddenly if you don't stop. So just be aware and be diligent. Better to be safe than sorry. Also, there was a question this afternoon, and I'll bring it up to you, was whether you need to get consent for assessments. Now, under the Healthcare Consent Act, doing an assessment to gauge someone's general condition, you don't need to. So if you're just, someone's coming in and, you know, they're coming in for that shoulder mobilization, you might do a little bit of an assessment. But again, going back to, it's always safe to just get consent, particularly where you may have to be touching that client or doing something that might cause pain. Like an assessment, in order to do an assessment of someone, there might be a risk that you're going to cause pain while you're doing it, because that's what you need to do. So it's always a safe and prudent practice to get consent for an assessment as well. Again, particularly if you're going to have to touch or manually mobilize someone. So just at the end of this slide, there's 3 areas where you can have presumed consent, and this is outlined in the Act. And basically the theme around those 3 examples are that there's really no significant change to the material risks or benefits. And then the last one there is that you can rely on a consent from another healthcare practitioner if it relates to the same treatment plan. And Heather touched on that though as well. Sometimes you still want to get consent along the way. So we'll move on to the next slide. How long does consent last? Well, if treatment is ongoing, then consent is ongoing. And consent, what I mean by that is the dialogue keeps going. Treatment plans need to be reevaluated and discussed with the client. And there's 3 areas outlined in the Act where consent must be obtained again or reconfirmed. That's when there's a change in the client condition, which I believe is question 11, and that would be true. And also when the practitioner proposes a change or the patient client is discharged or transferred. The bracketed portion is not mandated, but it's prudent. So if there's no change in a client, like they're not getting worse, but they're not getting better, and you had thought they would be getting better, you may want to discuss that with them, because you might find out some other information. Maybe they're not doing exercises at home or whatnot. So, or not in a rehab setting, but in a private, perhaps a wellness or sports fitness coaching where you're not really rehabilitating, you want to be sure to go over client goals, because you don't want to have a complaint that somebody comes forward and says, you know, they kept selling me more and more sessions and I didn't really want them. So just to be aware of that. If there's no change, you might still want to discuss with them. It's all about having these discussions with clients and including them in their healthcare treatment and goals. So, and also that consent must be withdrawn at any time, and you have to accept that withdrawal. So unless there's a question of capability, which brings us to the next slide, which is all about capacity, and this is where I hand it over to Heather, because I think she's probably slightly more capable than I am of handling this, as she's got a lot of experience in this. I could rhyme off the legislation to you, but she's going to make it more real. So Heather, over to you.
Thank you. So the definition in the Act for capacity is that the person is able to understand the information that's relevant, they appreciate the foreseeable consequences of making a decision, and that they can justify their decision. So I know that there are those of you out there in listening to us today that may have made a poor decision in the past, one that you are not proud of. I know I've made many. And the truth is that, capable people are allowed to make mistakes and they're allowed to make poor decisions. What we need to understand is, do they have the information they need to make the decision? Do they understand that information? Can they appreciate the foreseeable consequences of making the decision? And can they justify the decision? So some key things to remember: capacity or incapacity is not global, and it's not permanent when it comes to treatment. So just to sort of contrast this with the capacity to manage your own finances and property. So for finances and property, once you have been deemed incapable to make your own decisions, a substitute decision maker will make all future decisions on your behalf. The Healthcare Consent Act, and in the case of treatment, That is not the case. Each decision, treatment decision, is specific, and we as healthcare providers have to assess the capacity of the person to make that particular decision. Now, the legislation says that capacity is presumed. So that means we assume or presume that the patient or client in front of us is capable, unless they are showing us signs that they are not understanding the information that we're providing, that they are not understanding the discussion and appreciating the consequences of making this decision. So in some ways, with those three words, understand, appreciate, and justify, the legislation leaves it open, and it leaves it to our discretion as healthcare providers. So this is an assessment that we have to do as we're taking this valid and informed consent, and you have to be comfortable with your decision. You have to be comfortable that the person understands, appreciates, and can justify their decision. Just want to say quickly, if you're not comfortable that somebody is capable, you can always ask for a second opinion, bring a colleague into the room, or you can ask another colleague to propose the treatment to the person. So if you're not comfortable that they're capable, it just means that you can't propose that treatment. If another one of your colleagues disagrees and finds them to be capable, then they can propose the treatment and treat that person. The other thing that I want to highlight is that in Ontario, there is no age of consent. So the idea of assessing somebody's capacity to make a decision stands no matter how old the person, the patient, or the client is. You have to assess the individual's capacity to understand, appreciate, and justify the decision that they are making in the moment. So I always use this example of my 4-year-old son, Connor. So when Connor had a paper cut on his finger, he absolutely refused to let me put a Band-Aid on it. And I said to him, Connor, if you don't let me put a Band-Aid on your finger, it might get dirty, and then it will hurt a lot, and it might get infected, and that will hurt even more and be bad for your finger. And he said, Mommy, I don't want a Band-Aid. Well, as a parent, I choose to pick my battles, and I decided that he had the capacity to make that decision. He understands about pain. He understands, when something will hurt more than it already does, and I let him make the decision not to have a Band-Aid. However, the minute that there's any indication that that finger might be starting to become infected, increased redness, increased swelling, anything like that at all, obviously I am going to decide that at 4 he doesn't have the capacity to understand the consequences of a serious infection. And I then am going to step in and make a decision on his behalf that it needs to be cleaned, that there needs to be some antibiotic, and he's getting a Band-Aid. So there may be ethical issues around treating children, when and when not to bring in their parents, but it's about the capacity, assessing their capacity, looking at the risk and the consequences of the child making the decision. And if you feel they're not capable, that's when you move to the substitute decision maker, which is the parent. Again, Cara mentioned this refusal to consent. So just because somebody is not making a decision that we consider to be a good decision doesn't mean that they are incapable. So I mentioned this sort of off the top of this slide. Capable people can make poor decisions. They can make risky decisions. They can make what we consider to be poor decisions. But that doesn't mean that they don't understand, that they don't appreciate, and that they can't justify their own decision. So when you're assessing capacity, if we go back to that very first slide where you remember the stop sign, and it says, before proposing any treatment, a regulated healthcare provider must obtain a valid and informed consent from a capable person or their substitute decision maker if they're not capable. So what are some of those signs that they might not be capable of making the treatment decision? And remember, we are assuming capacity unless we see or hear or think that we are noticing some of these signs. So somebody is showing evidence of confusion or delusional thinking. If somebody is intoxicated, if somebody is experiencing severe pain or some sort of traumatic response, acute fear, anxiety, if there are signs of depression, I mentioned intoxication, any other observation that raises your concern about their ability to make this decision. And this can be not just something that they say, it can be something in their behavior, something in their pattern of communication. However, you want to be very careful, because when you assess somebody to be incapable of making a decision, you are taking a significant right away from them. So just because there is an existence or a history of psychiatric neurological diagnosis does not necessarily mean that they are incapable at this moment to make a treatment decision. And again, we talked about age. And just because there is a formal substitute decision maker in place, such as an attorney and a power of attorney for personal care, does not mean that that person is necessarily incapable of making this decision. We have to assess every decision individually. The other thing that is critical is just because there is a barrier to communication, a barrier for you to relay information and someone else to relay information back to you, does not mean that they are incapable or cognitively incapable of making the decision. So as healthcare providers, we have to make every effort to enhance communication. So for example, if somebody has a hearing impairment, if somebody speaks a different language, and we don't have access to a translator, well, that's not an incapable person. That's just somebody who can't communicate with you. And we have to do everything we can to enhance capacity and to enhance communication. And if you do make the assessment that somebody is incapable of making a treatment decision, it is not necessarily going to last. As Cara said, there are times when somebody is incapable in one moment, severe pain or intoxication, and 20 minutes, 30 minutes, 2 days later, they've regained full capacity, and now they become their own decision maker again. So what do we do if we deem somebody to be incapable of making their own treatment decision? The first thing that you have to do is you have to inform the client. You have to say, I have concerns that you are not understanding and appreciating the consequences of this decision, and I am going to ask your substitute decision maker to help make this decision on your behalf. We always inform them that they may still be capable to consent to other decisions, but for this particular decision, we are going to consult with the substitute decision maker. People, patients, clients always have the right to appeal your finding to the Consent and Capacity Board. So this is in the legislation to protect people's rights, and there are 2 applications that patients or clients can make to the Consent and Capacity Board. So the first one is to say, I disagree, I don't think I'm incapable, I want to make this decision myself, and the Consent and Capacity Review Board will do a review. The second application that somebody can make is, fine, I accept your finding of incapacity, but I would like to appoint a substitute decision maker that's different than a substitute decision maker that might be on the hierarchy. So that's another way that we respect somebody's rights even once they've been found to be incapable. So on the next slide is the hierarchy of substitute decision makers as it appears in the Healthcare Consent Act and the Substitute Decision Making Act. The hierarchy is just that. You start at the top and move down. Usually there are a lot of questions around the hierarchy, so it's difficult to sort of present in this context where we can't answer questions as we go. What you need to know about this hierarchy, and I will give you a hint. You will need to know about this hierarchy for your PRN practice assessment. You'll need to know that it exists. You'll need to know how to find it, and you'll need to know how to use it. You don't need to memorize it. You just need to know where to find it and how to use it. So the way the hierarchy works is you have to find the substitute decision maker that's highest on the hierarchy, that is willing and available to make a decision on behalf of the incapable person. So if we go right to the top, the guardian is a court-appointed guardian. Not a very common situation. A court-appointed guardian will have a documentation that says they're a court-appointed guardian. The attorney is a power of attorney, which you have probably heard of, and that is when somebody has created a document to specify who they would like their substitute decision maker to be. And it allows you to appoint somebody to the highest spot on the hierarchy. I'm going to skip representative for a minute. That's a representative appointed by the Consent and Capacity Board. For most people, they don't have a guardian. If they haven't done a POA, the first person on the hierarchy is going to be their spouse or partner. Then you have child or parent, brother and sister, any other relative, and finally the office of the public guardian and trustee. So you can move through this hierarchy as quickly as you need to find a decision maker. For example, if there's a power of attorney in place and you need consent to an x-ray that's going to happen next Thursday at 2 p.m., you need to make every effort to receive a valid and informed consent from that power of attorney until next Thursday at 2 p.m. Next Thursday, as that appointment is approaching for that x-ray that is required, you can then start to move down the hierarchy as quickly as you need to get a decision. So you can then contact the next person on the hierarchy and move your way down until you have a decision maker. Everybody in Ontario always has a substitute decision maker. If you can't find a decision maker, there is a treatment decisions unit at the OPG&T, and if you provide them the information that you would have provided either a capable person or their substitute decision maker, they will provide you with a real-time valid and informed consent for that treatment decision. Last thing I want to say about this slide, and I'll hand it back over to Cara, is that remember, you don't need a consent in an emergency. So if while you are attempting to find the most appropriate substitute decision maker, the situation becomes an emergency, you don't need a consent to treat in that situation.
Okay, thank you, Heather. That was great. I think I should add one thing to the emergency, that you often sometimes can go back after the fact and explain to the person what happened, and it's somewhat kind of like after the fact consent, but you just want to update them with everything that happened. And they may have known wishes. So if you're in a hospital setting, obviously you want to consult if there might be a DNR. Now, obviously, on one of the slides on, I think it was the first one on the basics of capacity, or one of the slides, we highlighted that, you know, this is a very complex area, and we could devote another hour to capacity. But if you're in a practice setting where this is, you know, something that you deal with, you know, maybe on a daily basis or a weekly basis, you really do want to educate yourself. You know, especially because once you make an assessment that someone is incapable, that's when you really have to know how to dot all the I's and cross all the T's, because it can be a very legal area. Hopefully, if you're in something like a long-term care facility, they'll have a lot of that institutional support there for you, but possibly not. But it is going to become an increasingly regular thing for a lot of practitioners because of the aging population. So just to keep that in mind, it's never a bad thing to educate yourself on this. Just to go back over some of the questions on the test, number 12, that only certain designated regulated health professionals can assess capacity. That's false. Every regulated health professional is expected to know how to assess capacity. So that includes KINs. 13 is about the whether or not consent is global, and it's not, so that's false. And number 14 is about the age of consent, and children under 12 are incapable. That is false, as Heather went through that really great example. Also, I just want to highlight what Heather said. When you find someone incapable, you know, we could also, and we may do a webinar in the future just on capacity, because there's a whole communication piece. And you'll notice that when she was talking about that, you don't tell the patient, hey, I think you're incapable or you're incapacitated. She was like, you know, I'm having concerns that you don't understand the nature of this treatment. So sounds a lot different. So you also want to make sure you know how to communicate that as well, which is question 16, and that one is false as well. You do need to inform someone that they're incapable, unless they are so incapable that they wouldn't understand that. But you should really always inform them of that in a manner that is respectful. And then question 15 is false as well. So we're going to move to the very last slide. We don't have too many questions at this point, so we'll move on to consent forms, because this is an area of concern from the regulator's point of view, and it's not just the College of Kinesiologists. There's a lot of other colleges that see way too much over-reliance on consent forms. And we always get questions, do you provide consent forms? You know, what about a boilerplate and all this? And the colleges do not usually provide consent forms because we don't want to be seen as saying, yeah, just use this and you're fine. Consent forms are not proof positive that you obtained valid informed consent. They may be partial proof, but they're not definitive. They may not list all the risks and benefits that are relevant to an individual patient client. So, you know, someone may have more of a risk of heart attack because they have diabetes or they're obese, and that particular treatment may relate to that. I can't think of a treatment off the top of my head. Heather may have that information, but someone else, yeah, exercise. So, and someone else may not have that same risk. So you really need to tailor the risks and benefits to patients. And a form, a template form, is not going to do that for you. A patient client may not understand what they are signing, or they may just not have read it. And let's all think about our own lives and how many times do we sign things that we have not read. Car rental agreements, bank agreements. How many times do we click off that we agreed to the privacy terms on something online? All the time we do it. And yes, you would think maybe people take their health a little bit more seriously, but people sign things and they didn't read them or they didn't understand them. And also there's an aspect of, you know, people are putting their trust in you. You're a regulated health professional. They're relying on your skills, knowledge, and judgment. So they may sign it thinking that you're going to talk about it, thinking, oh, well, for sure they're going to tell me more than just this. So there should be an opportunity to discuss the contents of the form if you're going to use a form. We're not saying you can't use them, but they must be used as a tool to facilitate the consent discussion, you know, to make sure that you remember certain things. Because maybe there are some risks that are just going to apply to everyone, and maybe you just want to make sure you don't forget any. That's okay. Consent forms should not be signed before seeing a practitioner and discussing the treatment. I love this. A couple of weeks ago I had a form that I signed because, you know, I just signed it. I know the drill. I just wanted to get in there, but I was given it, the receptionist gave it to me. And it said, you have had the opportunity to discuss the nature of the treatment and the risks and benefits with the practitioner. I'm reading this, and I told the practitioner after that, I said, you might as well toss that in the garbage, because how can I sign something that says I did something when I actually didn't? And most clients are just going to sign it because they just want to get in there. You know, they just want to see the person. But that's not going to protect you. And it's certainly not going to create necessarily a good therapeutic client relationship.
I can just interrupt you for 1 second, Cara. Sorry. The other thing that we don't consider at all when we're using consent forms is capacity. There is nothing on that consent form, like Cara said, that shows they understand or that you assessed whether or not they understood. So somebody can always come back and say, I didn't understand. And if you have not documented somewhere that you received a valid informed consent and you felt they were capable, they were capable and you received a valid and informed consent.
Right, exactly. So if you do use consent forms, they should be included in the record, but you should also be documenting the discussion that you had around signing the form. So like I said, it's a tool, and it can be a very useful tool when it's used correctly, but it is not the be-all and end-all, and it should not be over-relied upon. At the very beginning of the presentation, we talked about, consent should not be considered a routine step. It needs to be meaningful. It needs to be client-centered. It's going to help with the efficacy of the treatment. People who feel that they're included in their health care are more likely to do the things that they need to do, like eat right and exercise and whatnot, because they have a say. It's agency. So, we always get questions about consent forms, and at the end of the day, people, I think every practitioner is looking for that magic form that's going to encompass everything, but a form is not dialogue, and dialogue is verbal, and that's what we're trying to get at here. You have to be talking to your patients, and how much time you spend on it, as Heather mentioned, depends on the type of treatment you're proposing. Doesn't mean you have to spend an hour. If you're not cutting into someone's chest and performing open heart surgery, you may not. It's not going to necessarily be a hugely lengthy discussion, but still needs to be there. So just to finish with the quiz on the questions on consent form 17, a consent form is a form of express consent. It is a form of express consent, but that doesn't mean it's informed. So it's expressed, but it doesn't necessarily mean it's informed or that it's valid. 18, a consent form indicates informed consent was obtained. That's false. That's the whole point of this slide, is saying that it's not proof positive. A consent form that lists all the risks and benefits about a particular treatment is complete, and that's false because we just said that it's relevant. Risks and benefits change according to the patient client. So how can you have a preset form that's going to change with each client magically? I don't know. And a consent form, and then last one, a consent form replaces the need to document in the health record, and that is also false because, again, it's a tool to facilitate discussion, and you want to document that in the health record. So we'll just pause. There weren't too many questions. There was a question, and Heather, as you can see, you might just be able to add to it. If you are doing a new modality and it's your first time performing this modality, do you need to disclose that to the patient, even if they have already consented to the treatment? So the person saying they would assume that they would do so, but I think they just want confirmation on that. So do you want to take that one?
Sure. So when you're obtaining your consent for your course of treatment, you can mention the possible modalities that you may use during that course of treatment. And again, like Cara said, it all comes down to the risk. If there's any significant risk at all, you're always going to go back and reaffirm that consent. If there is very little risk, for example, using a modality, and it was a component of that course of treatment that you obtained a consent for, you can assume that there is implied consent there, assuming that they allow you to do it in the moment. Remember, people can always withdraw that consent. It all comes down to your comfort level. When in doubt, reaffirm. I mean, is basically, all you want to say is, I'm going to, do this ultrasound, I'm going to do this, explain what you're doing. This is what I expect the benefit will be, there's this risk, and is it all right if we do this now? You don't need to go through the consent form process. You've reaffirmed that they're comfortable with what you're about to do.
You took the words right out of my mouth. When in doubt, it's never going to hurt you to get consent. But hopefully we've helped. We're going to have to sign off now. It's 8 o'clock and it's getting late. But, hopefully you can, try to incorporate some practices and be conscious of obtaining consent, and still recognize that, you can be efficient with it, but it can be meaningful. We don't want to take up your entire practice with consent. We realize that when people come in for a half-hour treatment, they want their money, especially for pay-for-services. A lot of KINs are in private clinics. They want their half-hour worth of treatment. They don't want 10 minutes taken up with a long discussion on consent. But there is a way to do it efficiently, but still meaningfully, and I hope that that is what has come across, and how important consent is, not just as something to do, but something that really will help clients feel better about themselves and make the treatment more effective and make you a better practitioner in the end. So, like I said, look out for the FAQs at the within about a month of this presentation. And if you have any questions, you're always free to email me. So thank you everyone for attending on a cold Tuesday night, although hopefully you're in the comfort of your own homes. So, and once again, you will get a certificate that you were here, or some kind of acknowledgement that you were here, that you can claim as continuing professional development. Okay, so thank you and good night, everybody.